Well, I believe I am live right now, so thank you very much for joining me. For those that don't know who I am or why I am here, my name is Lior Samfiru. I'm the employment lawyer, and I'm here, of course, to talk about employment law. I'm here live to answer your questions, to tell you what you need to know about your workplace rights. I'm one of the founding partners of Samfiru Tumarkin LLP. We're the largest firm of our type in Canada. We operate in Ontario and BC and Alberta. And one of the focuses of our firm is employment law. We represent employees, we act for employees, we answer questions for employees, make sure that employees have all the knowledge that they need if they're facing a workplace issue. And that's why I'm here. You have an opportunity now to ask questions. If you're bothered by something at your work, maybe you've always wondered whether what your employer is doing is legal. Can they do this? Can they not do this? Maybe they're not helping you if you're sick or have a disability. Maybe you're being mistreated, bullied, harassed. Maybe you lost your job or are worried about losing your job. Whatever the issue, this is the time, this is the place to ask the question, type it in, press enter, I'll see it, I'll answer it. And you can walk away, of course, with all the knowledge and that information. And of course, you can also reach out to me off social media to have a private chat or private email exchange. Here's how you do that. All you do is you go to employmentlawyer.ca. Again, employmentlawyer.ca. You see that address on the screen right now. And when you go there, you'll see my phone number, my email address. It's all there. You can connect with me that way. That's the next step. So if you ask a question or something that I said triggers another question in your mind, you have the ability to connect with me so I can roll up my sleeves, get to work, and help you solve that workplace issue. But that's for later. Right now, I'm live. So again, those that are joining us right now, welcome. My name is Lior Samfiru. I know it's a mouthful, but you'll get used to it. I'm the employment lawyer. I'm here answering your questions live. I'm going to start answering questions right now. I encourage you to ask them now. Don't wait till the end of the session and then you may run out of time, or I may run out of time. Ask your question right now, guys, live. Take advantage of it. First question comes to us from YouTube, from N. Stinson. I have signed an official letter from my employer saying I am fully remote worker. Colleague complaint in an all-hands meeting that it wasn't fair that some employees get to work remotely while others do not. What are my legal options if my employer responds by asking me to commute to the office 1 or 2 more days per week? So here's the thing. If you signed an agreement with your employer confirming that you're working remotely, and that agreement doesn't give your employer the option to change that, then you have rights. Now, if the agreement says, no, you're working remotely, but we have the ability to change that, unfortunately, you don't have much of a choice. But if it doesn't say that, and if it doesn't give the company the right to change it, here's what your options are. Option number 1 is you can tell your employer, yeah, I'm going to do it. Fine. You can do what your employer says. Option number 2 is you tell your employer, no, I'm not going to do that. I'm going to continue working remotely as our agreement. Once you do that, your employer will either back off and leave you alone, or they'll decide to let you go. But if they let you go, they'll have to pay you severance. That's not a form of misconduct. Remember, an employer is allowed to let you go pretty much for any reason, but they have to pay severance. They would not be able to let you go for cause. They would not be able to let you go without severance. And depending on how long you've worked there, that could be anywhere from, 3 months of severance up to 24 months of severance. So those are the options that you have in that situation. They can't force you. They can't fire you for cause if you refuse. But again, I want to take a look at that agreement that you signed, because if that agreement says you work remotely, but we can change that, then there's not going to be those options. Hopefully that makes sense. If there's something that I've missed or something you misunderstood, or if you have a follow-up question, ask it. I'm happy to answer that as well. All right, let's see. Next question from Ziggy on YouTube. My job position was drastically reduced in early 2020. I warned my boss at the time that this will cause me many health issues in the future. I asked him multiple times to put in an email, but he never did. He shrugged it off and kept me there until I ended up on short-term disability earlier this year. My short-term disability is ending in a month, and I'm awaiting approval for long-term. It is very difficult as my plan has been 2/3. I'm not sure what that means. What should I do? So, well, ultimately, if you can't work in this job for medical reasons, all you need is a doctor's note saying you can't do that. then your employer has to accommodate you. In fact, you could have done that back in 2020 or anytime ever since, simply had a doctor's note saying, this job for health reasons you cannot do. Then they would have had to find something else for you that complies with your medical limitations. So right now you're on disability. You can stay on disability until you don't need to be on there anymore. And then when you're ready to come back to work, give that doctor's note to your employer. If they say, too bad, we don't care about the doctor's note, we'll do whatever we want, that's illegal. That's a human rights violation. There's significant consequences if that happens, and you have to call me right away. But bottom line is, doctor's note is all you need. Could have done that 2 years ago. You can still do that now. Without that doctor's note, your employer can do essentially what it wants in terms of keeping you in this job. But as long as you have a doctor's note and the doctor's note says you can only do this job or that job, they have to find a way to make it happen. Okay, hopefully that makes sense, Ziggy. Any follow-up questions, let me know. And for Ziggy, for anyone else that wants to connect with me off air, easy to do, just go to employmentlawyer.ca. For those joining us, welcome. My name is Lior Samfiru. I'm the employment lawyer. I'm answering questions right now live here on this forum. So if you're watching me, you have an employment law question, ask it. I'll see it. I'll answer it. I'm going to continue answering questions right now. Our next question comes to us from Rocket. If a company has litigation insurance, are they less likely to settle and just go to trial because it's not costing them anything while the employee is incurring legal fees? So it's not litigation insurance. In some cases, the companies may have wrongful dismissal insurance if someone starts a claim for wrongful dismissal. So the company may be eager to, they may not care about going ahead, but the insurance company is going to put pressure on the company to settle. Why? Because the insurance company doesn't want to have to continue paying legal fees. And if the insurance company feels that the company is not being reasonable, they'll tell them, wait a second, if you don't settle, we'll stop paying you. We'll stop covering you because you're not being reasonable. So no, it's not a concern. That insurance is, in fact, I find it easier to settle with companies that have that insurance than with companies that don't have that insurance. Okay, Susan on YouTube asks, what can I do when I'm bullied in the workplace? Good question, Susan. It's certainly one that unfortunately I get asked quite often. So the first thing you want is to find a way to document that somehow. If it's in an email, have emails. If there's something you can record, a recording, a witness, or even write in some sort of a journal. On September 28th, this is what happened. On September 29th, this is what happened. Some contemporaneous notes. Once you have that, you need to talk to someone within the company, HR, the owner, whoever the right person is. You have to understand that they don't have the right, they can never punish you for complaining about harassment. They have the legal obligation to take it seriously, to investigate, and to rectify that issue. They cannot punish you in any way, shape, or form. So that's what you do. Now, if you do that and they don't do anything, or maybe there's no one you can talk to, maybe it's the owner that's harassing you, so who are you going to complain to? That's when you call me and you let me deal with it, okay? Because being bullied, being harassed is a big deal. You shouldn't have to take it. So if you can deal with it internally, as I said, do it. If you can't deal with it internally or you tried, let me know and I will deal with it. Okay, and to connect with me, very easy to do. Just go to employmentlawyer.ca. Again, employmentlawyer.ca, and I'll be more than happy to talk to you and help you and make sure that this issue gets resolved. So thank you for that, Susan. Next question comes from JX2 on YouTube. Okay, if additional duties are added and you treat that as a constructive dismissal when a raise is not given, what happens when an employer argues that the position is similar and your refusal emits several severance obligations? Well, remember, it's not every change that results in a constructive dismissal. I'll give you an example. If you operate machine A and the company says from now on, instead of operating machine A, you're going to operate machine B, that's probably not a constructive dismissal unless there's physical issues that you can't operate machine B. So it's a question of, is what they're doing constructive dismissal or not? It's not up to the company to decide that. The law decides that. So without knowing what kind of a change in duties we're talking about, I can't answer that. If it's something where you're given a lot more work, double the work, or maybe it's a position that could be seen as a demotion, that would be a constructive dismissal. If it's just a bit of a different job, it may not be a constructive dismissal. Bottom line is you don't quit, you don't say constructive dismissal until you talk to me, okay? You only ever say constructive dismissal after you've talked to me and I've said, yes, that is a constructive dismissal. In that situation, you have nothing to worry about. But if you make the call yourself and it turns out that you're wrong, then yeah, you may have just resigned and not get anything. That's why constructive dismissal should never happen. Resignation should never happen without talking to me first, okay? And again, to talk to me, to connect with me, employmentlawyer.ca. All right, let's see. Next question from Four Season Family on YouTube. Went through a harassment investigation. Employer hired a third-party investigator and found my claims unfounded. Do I have options? So first of all, the question is, why did the investigator find that it's unfounded? Did they make mistakes? Did they not talk to people that they needed to talk to? Did they forget to look at something? Or did they just look at it but ultimately decided against you? So if there's a good reason that you can show why they made a mistake, you need to put that in writing and show that to your employer. If there isn't, you just disagree with their finding, then ultimately right now the company doesn't have to do anything because their investigator said that they couldn't corroborate it. So you have to start from scratch right now if you're still going to be harassed to build up a case. Have a recording. Okay, recording works really well. If someone is going to talk inappropriately to you, have them record them. They don't have to know about it. You can record them. So have a way to prove that. And then when you have the proof, go back to the company. Okay, if they hired an investigator, in many cases, there's not going to be much that you can do if the investigator did their job properly and ultimately found that the harassment can't be corroborated. So if you need to talk about this, if you want to get some help, if you want to, dig into this a bit deeper, happy to connect with you. You can always reach me. You see that address below me, employmentlawyer.ca. Again, employmentlawyer.ca. I'm going to continue answering questions. I am still live. You're live. Ask your questions right now. Those joining us, I'm the employment lawyer, Lior Samfiru from Samfiru Tumarkin LLP, and I'm here answering your questions. All right, next question is from Christian. Wow, Christian has a very long question. Let's see if I can get through it. I may not be able to, but let's see. Question about a wrongful dismissal. Can my employer firing me from my position before my 3-month probation period without cause, even if I had 2 work-related accidents within my first month of work? Okay, so I think I understand. So ultimately, your employer can't fire you because you've had injuries. Absolutely not. That's illegal. Even if they say that it's a different reason, but you had work-related injuries, in most cases, it'll be illegal to let you go. Because clearly, if you couldn't work there properly because of your injuries, it is because of the injuries that they're letting you go. So that's number one. Number two is I want you to remember that even in the first 3 months of employment, if you're let go, you may still be owed severance. And that severance may still be a few months' pay. So you may have only worked for a company for 2 or 3 months, and you could be owed 2 or 3 months of severance, even more than that. So obviously there's enough here that we need to discuss this. So by all means, reach out to me off social media. I want to find out more about the timing of your injuries. I want to find out when you were off, how long you were off, what the company said to you. And then on that basis, we can figure out what the appropriate course of action is, Christian. So to connect with me, again, employmentlawyer.ca. Again, employmentlawyer.ca. And of course, you'll see the phone number there, email address. It's all there. All right, next question right now on Facebook from Sumesh. What is the statute of limitations in terms of time to file a claim for being terminated? It's 2 years. So you have 2 years from when you are let go to file a claim for wrongful dismissal. So your legal rights are alive and preserved for a period of 2 years. But remember, that's a very firm 2 years. It's not 2 years and a day. It's 2 years. If you go over it by a day, then unfortunately you're out of time. So don't sit on your rights. Okay, if you've been let go and you're coming up on that 2-year period, let's talk immediately today. Okay, and in fact, you should never wait at all. If you're let go, you should talk to me immediately, the same day even. So hopefully that makes sense, Sumesh. If you have follow-up questions, please ask. I'm happy to answer. Andrea has our next question on Facebook, or Andrea. I left my career of 16 years. My last pay, including vacation pay, seems like it is not accurate. How do I verify what the amounts should be? Also, I believe they are calculating my time as of 2012. I started there in 2006. The company did change names during the time, but I have been working with the same owner throughout. So bottom line is this: ask the question. Okay, they have to by law provide you a breakdown of their calculations. If they don't, let me know. I'll get that breakdown. And once you have the breakdown, we can see if they've done it appropriately or not. And again, in terms of vacation, they have to pay you any accrued vacation from when you're accrued vacation that you had as of the time you were let go or the time that you resigned. Any accrued vacation they have to pay you out. And your seniority does count from when you started originally, even if there was a change in the meantime. So you ask the question, they have to answer. If not, let me know and I'll ask. Next question is from Jacob on Facebook. The company that I brought up to you a few weeks back, I would have no recollection of that, is accommodating me when we go to permanently work from home with a temporary schedule that works with my home situation. I'll call your office if anything changes. Sounds good. Looking forward to chatting if you ever want to. Rocket has the next question on YouTube. Do you find that employees who witness harassment in the workplace are less likely to be a witness and speak out against the employer due to fear of losing their job? Yes, absolutely. I think that is very common and understood, unfortunately. JX2. JX had a question about her employer changing her job duties. Says, I just meant if they keep adding duties. I'm also wondering if a company or even a union can decide one day to put in a minimum wage, or if that is age discrimination. I'm not sure what you mean by minimum wage. If a company keeps adding duties, the question is, how much does it change your job? So if you had 6 duties, now they added a 7th, and it's not, as long as it's not that big, then it's not a constructive dismissal. If they added a lot of duties and now your job is very different, then it is. So I need to understand what your job was before, what duties have they added, what is your job after, how many more hours do you have to work, or how much harder does it make your job? And on that basis, I can tell you if it's a constructive dismissal or not. One thing to remember is there's no such thing as constructive dismissal for union employees. In fact, anything you hear me talk about only applies to non-union employees. If you're a union employee, very different situation, and only the union can advise you on your rights and can help you enforce your rights. Okay, so what you hear here is only with respect to non-union employees. All right, great questions today, guys. Keep them coming. I'm still here. You have time, so please. Next question is from Valerie. Can someone be fired while on stress leave? And also, if returning to work, can they demote can someone be fired while they're on stress leave? And also, if returning to work, can they demote someone from their prior position? So no, someone can't be fired on stress leave unless it's clear that there's never going to be a job for them. For example, you worked for in the sales department and they shut down the sales division as an example. Well, in that case, everyone is let go, so you can be let go as well. But short of that, no, you can't be let go. Here's what happens. If you're off on a medical leave, stress leave, disability leave, doesn't matter, your employer has to wait for you to be able to come back to work. And when you're ready to come back to work, they need to make every effort to find a job for you. If it's the same job or a similar job, they have to make all efforts. Now, if they've tried and there's nothing, okay, then they can let you go with severance. Or if they've tried, but the only job is a very different job, it's a demoted job, then if you don't accept that, you can treat that as a constructive dismissal. So you can't be let go because you're on stress leave. You certainly can't be let go just because you're on stress leave or while you're on stress leave. The decision as to whether there's a job for you or not has to be made when you're ready to come back from that leave. All right. So whether you're off for a month, a year, or longer, it's when you're ready to come back, not while you're on stress leave. All right. So that's the answer for Valerie. Valerie, if what I said didn't make sense, let me know. Happy to clarify. Ask away. We have another 10 minutes or so, guys. I'm going to continue answering questions right now. You have probably a last chance to type in a question. So take advantage. Again, those joining us, I'm Lior Samfiru, the employment lawyer. As you can see, I am here live answering your employment law questions. Next question is from Sumesh. I think Sumesh has a follow-up. I was terminated on October 8, 2020. Your intake officer said time has passed and your firm could not help me. No, she wouldn't have said that. She would have said that we may not have the ability to do it before the October 8th. Because if you're contacting us this late, we may not be able to get the claim out the door, in the next week. That's the problem. So you still have time, okay? It's just that if you contact someone at the last minute, you can't expect them to be able to drop everything and get something done that quickly. That's why time is not on your side. So you still have time. You're not out of time. We never said that we're out of time. It's just that if you contact us at the last minute, we need more than a few days so we can do this right and we can do a good job. Next question from Four Season Family, another follow-up question. If a harassment investigation has concluded, does an employer have an obligation to release the full report or just a summary? They don't have to release the full report, at least not at this stage. Just a summary of it. When they will have to release a full report is if there's ever any legal action. As part of that process, they would have to, of course, release the full report. But no, they don't have to release the full report. I don't know why they wouldn't, but there's no legal obligation to release it, just a summary. So next question is from Andrea. What happens to an employer when they violate the right to disconnect law? Nothing, unfortunately. There's really no repercussions right now. That's the problem. That it doesn't have any teeth, this law. And I've spoken about this and given interviews. As it stands right now, the only thing they have to do is to have a policy. Whether they follow it or not, there really is no teeth right now. So it's a law without any teeth. Rocket says that I didn't answer his second question. I did answer it, actually, Rocket, so it's there somewhere. So we still have some time, guys. So ask questions if you have questions about employment law. I'm here to answer those questions for you live. Now, here's the thing, guys. Let me tell you about another tool that you absolutely have to know. That's called our Severance Calculator. Everyone has a right to know how much severance they're owed. Whether you've just lost your job, whether you're worried about losing your job, or maybe you're just curious, you want to know how much severance you'd be owed if it ever comes to it that you lose your job. So here's what you do. You go to pocketemploymentlawyer.ca. You see that address below me. It's pocketemploymentlawyer.ca. One of the tools that we have there is our Severance Calculator tool. By the way, that tool has been used by over 2 million people across Canada. It works amazingly well. And all it does is it tells you and it calculates for you how much severance you are owed. You answer 3 questions: your age, your position, the length of your employment, and it's going to tell you how much severance you're owed. It's completely free. It's completely anonymous. You don't have to put in your phone number. You don't have to put in your name. You don't have to put in the company's name that you work for. None of that. It's just there for your information. pocketemploymentlawyer.ca. Now, before you even use it, have a number in your head. Think in your head, how much do I think am I owed? And then use it. I'll almost guarantee you're going to be surprised by what the real number is and how much higher that real number is in comparison with what you think you're owed. It's not a week per year. It's not 2 weeks per year. It's a lot more than that. So just go to pocketemploymentlawyer.ca. And by the way, on that same website, pocketemploymentlawyer.ca, we have other tools. We have a tool that allows you to find out if you've been constructively dismissed. We have a tool that allows you to find out if you're an independent contractor or an employee. Many people have been misclassified. We have a tool that allows you to find out if what you did can allow the company to let you go for cause, and many other things as well. It's a great tool. I've tried to take the most common issues that I deal with and create that tool to allow you to get answers to your specific situations right away. So check out pocketemploymentlawyer.ca. All right now I'm still live for a little while, so I'm going to continue asking questions. You may have a time to squeeze in one last question, so take advantage, answer that or ask that question. I'll answer it. All right, from Cookie Monster. I remember Cookie Monster on YouTube. I was in a car crash, and my employer tried to let me go. I'm not sure what that means. I gave a doctor's note with a return to work plan. My employer said I had to complete EDMP counseling before returning to work, which I did not qualify for. I phoned HR 4 different times saying that I didn't qualify, but did not return any of my calls. Well, this is where I need to get involved, okay? Because your employer should follow what your doctor has to say. So they can't impose other conditions. If your doctor says you're ready to come back to work, that's it. And they can't impose this counseling or that counseling. You need to give me a call, okay? As soon as possible, connect with me and get the phone number at employmentlawyer.ca. Again, employmentlawyer.ca. My phone number is there. My email address is there. Everything you need is there to reach out. Let me get involved. Let me do what I do, and let's get this resolved, Cookie Monster. Okay. Giovanni has the next question on YouTube. I gave my doctor's orders to my employer, but I didn't provide a letter from my doctor. Can my employer refuse to follow my doctor's orders? Well, yes, because if you didn't give a doctor's note, how do they know what your doctor has to say? If you simply told them, this is what my doctor says, that's not enough. You need to actually give them a doctor's note that says, here's your limitations, here's what you can and cannot do, or here's what accommodation. It has to be something from the doctor signed by the doctor. You telling them what your doctor said is not going to be enough, okay? Get that doctor's note. It's very easy to do. And if they don't do everything your doctor says, call me right away. Again, employmentlawyer.ca. All right. AX2 has a follow-up question. For my last question, I meant to say minimum age. When I said minimum wage, it was a typo. Can you address this? First of all, if you're part of a union, then I'm not even going to go there. Only the union can answer that. And in terms of minimum age, well, I don't know exactly what you mean by that. That they're saying to work here, you have to be a certain age. You know, you have to be at least 20 years old. Well, it depends. They can't hire people based on age or fire people based on age unless there's a job duty or a job responsibility that makes it clear that you have to be a certain age. So, for example, if you're going to be, I don't even have an example. The reality is that unless there's a good reason to have an age restriction, and in most cases there isn't a good reason, it's a human rights violation. An employer cannot hire someone, fire someone, or restrict the job based on age, whether it's old age, young age, can't do that. But again, if you're part of a union, only the union can tell you if that's legal or not. In a non-union situation, an employer can't do that. So hopefully that makes sense. I think I'm caught up on the questions here. So if you have any other questions, hey, ask it right now. I'm happy to answer it. But let me tell you about something else. You know, one of the things I've been seeing very often, especially recently, is situations where employees are let go and have been offered not half of what they're owed, not a quarter of what they're owed, a tenth of what they're owed. They may be owed 10 months and they're offered 1 month. So I've seen those severance offers get even worse than usual. So it's even more important than it ever was to call me if you lose your job, okay? Don't wait. Chances are whatever you've been offered, if you've been let go, you're owed much more. The good news is it's not difficult to get you what you're owed. It starts by reaching out to me. Last question today from Ray. I'm owed $34,000 plus vacation and back pay from a corporation that has no funds to pay me. They do have a board of directors liability insurance. How successful are these claims? So directors of the company are personally liable for back wages. Okay, so if you're owed back wages, they're personally liable, which means it's going to be very easy to get this resolved. You just got to give me a call, or you can even go for that to the Ministry of Labor. Regardless of liability insurance or director's liability insurance, you'll be able to get that. So now severance, you're not going to be able to get from directors, but unpaid wages, absolutely, they have personal liability, so it's easy to resolve. Guys, I think that's the time we have for today. So thank you. Lots and lots of questions. I think I got through all of them. Happy to answer more. To connect with me now, once I'm turning off this camera, very easy to do. Just go to employmentlawyer.ca. Phone numbers there, email address there. If you prefer to fill out a form, it's also there. And of course, you can read out a lot more about your employment law rights. Guys, my name is Lior Samfiru. I'm the employment lawyer, one of the founding partners of Samfiru Tumarkin LLP. We operate in Ontario, in BC, and in Alberta. And if I or my team can ever help you, we're here. We've got your back. Always reach out to us through employmentlawyer.ca. I'll be back next week. My colleagues will be back also later this week doing sessions just like this. Thank you very much for your time. Thank you for the questions, and we'll talk to you again very soon. Take care.